Breaking news. IPOB leader Nnamdi Kanu sues Chief Judge of the Federal High Court and the Chief Registrar for barring journalists and the public from terrorism trial. Honestly, Nigeria is a confusion state. They don't have any tangible case with Mazi Nnamdi Kanu. They are just using tactics to buy time to keep the man with them because they to believe that Nnamdi Kanu has finished Nigeria with truth, but just confused, not knowing what to do. Kanu is a poison to Nigerian government. They should just let him go. You understand? They just have to let him go. The leader of the indigenous people of Biafra, Nnamdi Kanu, has sued the Chief Judge of the Federal High Court of Nigeria, Honorable Justice John Taku, and the Chief Registrar of the Federal High Court of Nigeria over the new practice directions on hearing of terrorism cases. Some weeks ago, the Chief Judge issued practice directions on trial of terrorism cases, noting that the distance and the size of perimeters to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. It means terrorism trials, including the ongoing trial of Nnamdi Kanu and other related ones, will be done secretly, even without journalists, except the judge rules otherwise. Kanu's trial by the Nigerian government, which continued on April 8, was the first casualty of the new directive. In an originating summons with suit number FHC/ABJ/CL/550/2022, which was filed on Monday, April 25th. Kanu's lawyer, Ifeanyi Ejiofor, sought answers to whether the powers confirmed on the first defendant, Tahu, includes the power to make directions for regulating trials of terrorism offenses in the Federal High Court, considering the provisions of sections 336, 1 in bracket, and 364 B and B of the 1999 Constitution of the Federal Republic of Nigeria as amended. Ejiofor urged that the said practice directions were issued without the approval of the Federal Executive Council, formerly the National Council of Ministers of the Federal Government of Nigeria. The lawyer said the IPOB leader was not afforded any hearing before the said directions were made by the justice. He further urged that his client, Nnamdi Kanu, against whose interests he said directions were primarily made, has already been publicly tried and condemned by the federal government of Nigeria and her Attorney General. That I know as a fact that it is in the interest of justice and fair hearing that the plaintiff, who has been so tried and commended publicly by his accusers, enjoys a public trial devoid of restrictions contained in the practice directions, he added. He also noted that the practice directions apply to and affect the proceedings in charge number FHC/AB/CR/383/2015 pending before Honorable Justice Binta Iyako of Court Number 2, Federal High Court, Abuja, in which the plaintiff is being prosecuted under Terrorism Prevention Amendment Act. Ejiofor further urged the court to restrain the defendants and their agents from applying and enforcing the provisions of the Federal High Court Practice Directions on Trial of Terrorism Cases 2022. Other relief sought include a declaration that the provision of order of the Federal High Court Practice Directions on Trial of Terrorism Cases 2022 are already the subject of Section 36B, A, and B of the Constitution of the Federal Republic of Nigeria, 1999 as amended, and consequently, they are utile, inoperative, and outrightly ultra verbs. The first defendant, invalid, non-void, and non-effect of whatever. A declaration that the failure of the first defendant to first seek and obtain the approval of the Federal Executive Council or the National Council of Ministers of the Federal Republic of Nigeria prior to enacting the Federal High Court Practice Directions on Trials of Terrorism Cases 2022 as required by Section 44 of the Federal High Court Act renders the Federal High Court Practice Direction on Trial of Terrorism Cases 2022 ultra verbs null and void. A declaration that Order 3 Rules B, 3B, and D of the Federal High Court Practice Directions on Trials of Terrorism Cases 2022, which respectively empower a Federal High Court trying terrorism cases to receive evidence by video link and to receive written disposition of experts' witness, are inconsistent with items 23 and 68 of the Executive Legislative List, as well as paragraph 2b of part 3 of the second schedule to the Constitution, which confers on the National Assembly the executive power to make rules of evidence, both substantive and objective, and are therefore ultra verbs null and void to the extent of the constituency. The declaration that Order 5 Rule 2 of the Federal High Court Practice Directions on Trial of Terrorism Cases 2022, which provides that a person who contravenes an order or direction made under these directions should be deemed to have committed an offense contrary to Section 34(5) in brackets of the Terrorism Prevention Act 2011 as amended, because the National Assembly had already covered the field viewed Section 34(5) of the Terrorism Prevention Act 2011 as amended. A declaration that the rule-making powers of the first defendant under Section 254 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, are limited to the premises of the Federal High Court and do not extend to outside its perimeters, which are under the exclusive responsibility of law enforcement agencies, which as the police, the DSS, etc. An order of this Honorable Court declaring the Federal High Court Practice Directions on Trial of Terrorism Case 2022 unconstitutional, ultra verbs, invalid, none and void, and of no effect. The defendants are expected to appear within 30 days after the service of the summons on them, inclusive of the day of such service, case, and appearance to be entered for them to this summons, which is issued upon the application of the above named plaintiff for the determination of the following question. It was further noted that though both of the Federal High Courts may appear by entering appearance personally or by a legal practitioner, either by filing the appropriate process as in Order 7 in response at the registry of the court where the summons was issued, or sending them to that office by any of the method allowed by the rules. Okay, the statement reads. So guys, what do you have to say concerning this? Let's hear from you. Thank you very much. Bye.